everybody. Good morning. I am so delighted to be with you here today, and thank you for coming out this early. Thank you for the introduction, and a huge thank you to Nancy and the team, Katie as well, for making this conference happen. I told Nancy that getting me here was kind of an easy sell. Part of that is because, yes, space is cool, right? But also Huntsville is cool. I know a little bit about the storied tradition of research here, of STEM excellence, and I know my family is, and those who are not with us would be really excited for me to be here. My grandfather was an engineer, although a very different kind, a ceramics engineer. My father's in the medical sciences, my brother studied computer science, and here I am, always the most popular guy in the room, the lawyer. But I like to think of what I do as trying to help build bridges between intellectual communities that don't always talk to each other, between the folks doing amazing work, many of whom you'll meet here at this conference, in science and technology, especially here on AI issues, and those who are working on some of the really difficult questions of law and ethics and policy that these technologies force us to confront. And I think it's a two-way street, which is one of the themes of my talk. Certainly, I view part of my job, my task, as helping introduce the folks I work with to the kinds of things we're learning about at this conference, right? But I also hope that through this talk today and through other work that I do, I help build bridges in the opposite direction and help people who are working on technologies like the ones we're learning about think critically about the challenges that we're going to have to face using non-technological tools, namely, as I'll discuss, democracy. So what do I mean by all of this? I want to stress at the outset, just to frame my remarks, a few themes that are going to run through the talk. And apologies for visual learners who are here today. I hate speaking with slides, so I'm going to try to make this more of a conversation. We're going to leave time for questions at the end because I really do want this to become a dialogue. And if I'm getting to the point where that's looking impossible, someone from the very helpful team I know will signal to let me know. So the first and probably the most important theme that I want to stress is that AI is going to force us to tackle a series of challenging legal and ethical puzzles that we may not actually be very well prepared to tackle yet. Why the pessimism? And I did warn Nancy I might be the Debbie Downer of the conference. The pessimism partly arises out of my own research. AI isn't new. Most of you here know that. We're in a new generation of AI, but some version of AI has been with us for a long time. And when I say I study AI in the law, people tend to think what I mean is that I study ChatGPT. But actually, I'm more focused on what you might call an older generation of machine learning, the kinds of tools that businesses use to make predictions about all of us, our needs, our wants, our foibles, our likely mistakes. And I think that those tools, which have been around for a while now, already forced us to answer or at least ask a lot of these really hard questions, and we didn't do it. We didn't just not solve, it's not just that we didn't solve the problems, we never really had a big conversation about what they are and how to go about it. And I'm going to use the first person plural pronoun a lot in this conversation, and when I say we, I certainly don't just mean we lawyers or, God forbid, we law professors or the Yale Law School. I mean we, all of us. This is a really important time for collaboration between people who have different points of view and also who work on different areas of the issue. So I hope today that, first of all, I leave you with a sense of urgency, because it's not just that we have all these new puzzles to solve, we actually have old ones that are still festering out there. We have people who have been harmed, who are being harmed, and we may think that's okay, and it totally aligns with the way we think society ought to work. We may not think it's okay, but we haven't really confronted those issues from the past, and so I think we need to hurry up. All right, the second theme related to the first is that, again, this isn't just a problem for the quote-unquote experts to solve. It's not just for the presenter-type people you see here today or the technologists. Certainly, again, not a problem for lawyers. It is, again, a problem for democracy. Law does not descend from on high, right? At least not in our system. We are supposed to have a role in deciding how these things work. At least when it's going well, there's a collective conversation that happens, right, full of participation from different corners of society. That doesn't mean we all vote on every problem. We have representatives. But in theory, there's a bit of back and forth there. I think this isn't happening enough yet, as I've said. And I also want to explain why I think that's again, a two-way problem. Certainly, it should make us concerned about democratic outcomes if we're not all part of that conversation, if our representatives aren't even having that conversation. A lot of the decisions being made in the inner recesses of boardrooms are sort of making the decisions for us. We may like those decisions, or we may not, but the outcomes may not reflect our views, our ethical principles, et cetera. But also, when we lose the opportunity to participate in those conversations, there's also the risk that our ethical views kind of get frozen in time. I don't mean first principles. We all have our first principles, right, that inform our views of things. But it is through that participation, through that conversation, that we get to test our first principles in their application, see where they make sense in the details, where they don't, where they might need to be updated, where there are gaps we've never thought about. We're all losing that opportunity if we don't come together and try to talk about what's happening in AI. But, and this sounds a little silly, even I snickered when I thought of it, there may actually be a sense in which this kind of AI moment is actually an incredible opportunity for American democracy. Why do I say that? And I promise I'm getting into the AI details first. I just wanted to frame why I'm interested in this and why I think people should care. So we've all heard about how AI can imperil democracy, right? We've heard about algorithms that target each of us based on our pre-existing views, so we never hear about anything else. We've heard about AI-generated misinformation. We've heard about human-generated misinformation that uses AI to find its best audiences, right? These are all really serious problems. But why a double-edged sword here? AI is one of those few issues that kind of elicits a shrug from a lot of people. Not a disinterested shrug, but a genuine sense of puzzlement where we don't know what to do. People who are very confident about how they feel on all sorts of different issues really have a hard time with a lot of these questions. I think that might be a good thing. It might be the rare moment when we can all kind of, or at least many of us, can see the benefit of sitting down with each other and trying to work through all of this. There aren't a lot of issues like that where I think the majority view is, I'm just not sure this is really hard. And I think we should try to make use of that. All right, the third theme, getting more into specifics, is a little more about law itself, but there's a space tie-in, which I was very excited about. And I am borrowing this from an esteemed professor at the University of Michigan, Peggy Radin, although she's not the only one to have written in this theme. So this theme is about asymmetries, or the lack of fit between our legal structures, the legal ideas that animate all sorts of different areas of law, and I'm going to talk about a bunch, the lack of fit between those ideas, the structures, and the real world as it's evolved. And Professor Radin actually thought one of the best ways to understand this was going back to Ptolemy's epicycles. Nod if this sounds familiar. I know astronomers in the room have thought about this. So, as you all know, we once thought the Earth was the center of the universe, right? And the sun and the heavenly bodies revolved around it. But the Greeks were good at mathematical observations, and they noticed that what they were seeing in the sky didn't quite match the theory. But instead of changing the theory, they invented this thing called epicycles, emerges out of Ptolemy's theories in particular, to basically say, well, maybe actually everything revolves around the Earth, but there are these other little circles they're doing in the heavens that account for these distortions we're seeing. And this stuck around for more than 1,000 years before the community of science kind of decided actually maybe it makes more sense that the Earth is not the center of the universe. Why am I talking about this? Peggy Radin, like me, was really interested in consumer protection, in particular contract law. And what she was noticing was that the way contracts actually work in our society and the way that contract law assumes they work are really two different things. Contract law emerges out of a time when you and I might be haggling over a goat, right? And yes, we might reduce our negotiations to writing at some point, and then if one of us didn't perform, we could go to a court and say, look, he said he would give me bushels of X or Y or Z for the goat. But the idea was that we were both kind of participating in the process. And what Peggy Radin noticed was that, along with some other academics, was that when we click I agree to terms and conditions on the internet, it just bears no resemblance to what it is that contract law thought we were doing. In academia, we like to say law has both a descriptive and a normative function. What we mean by that is law is supposed to both kind of sort of accurately capture what's going on in the world, but it also says how the world should be. It says what a contract is and what a contract should be. And she was noticing that mismatch. Part of the sort of macro theme for my talk today is that this is not at all unique to contract law. It actually kind of reverberates across the legal system, where we have these decades or centuries old ideas about how these legal structures do work, how they should work, that are increasingly out of step with the world as it is. That doesn't mean we need to throw the baby out with the bathwater, but it does mean that we need to devote a lot of serious attention to figuring out where maybe, just maybe, the theories themselves need a little bit of updating. In most of these cases, as you'll hear, I'm not even going to prejudge what the right answer is. I simply want to sort of present to you all a sort of 30,000-foot view of these puzzles. It did occur to me that for this audience, 30,000 feet is not that impressive, but you get what I mean. All right, so let's dive into some case studies. A little more first on contracts, because I've already introduced you to what I'm talking about. So again, the basic structure of the problem was that contract law, which we inherited from England, was meant to govern these kinds of private negotiations between people and give them the opportunity to invoke the power of the state to enforce them, right? It's kind of, you'll see some scholars even talk about it as an almost mystical or magical power. It's kind of amazing that you and I can agree on a thing involving no one else, and by virtue of having done that, we've sort of guaranteed that the state can come in later and, award damages to one of us for not doing what we'd said. It gives a lot of power to promise, right? I'm summarizing ideas from a lot of other folks. So that's the basic structure. That's what it was supposed to be, and here's what we have, right? We have I agree to terms and conditions we've never read. There are also situations where, for instance, even long before the current era of AI, you'd buy, say, a toy for your child on the internet or on the phone before the internet. You'd pay using a credit card, the toy would arrive, and it would be wrapped in terms and conditions that say, if you open this box, you agree to X, Y, or Z. Courts generally enforced those contracts, and Peggy Radin said, why are we doing this? This is not at all what the law says contracts should be. But now we're in a really weird moment. We went from personalized contracts to what Radin calls massively distributed form contracts, right? Massively distributed boilerplate contracts. We're going back, maybe, to personalization. Hyper-personalization, hyper-individualization that AI allows, but it's asymmetrical. What do I mean by that? Sometimes the contracts we sign or the transactions we engage in are being hyper-personalized to us. We're not just consumer number 10,001. We are who we are with our needs and wants and all those things. But we, on our side of the transaction, don't know it. We don't know that it's being personalized. Or if we do, we don't know how or why or to what effect. So why does this matter for contract law? So first, just these are a couple examples. There's a lot of ways. Courts generally don't like refusing to enforce a contract because it seems unfair. For a lot of good reasons, right? It's hard for a court to say, we know better than the parties that negotiated that the contract is unfair. Part of the theory underlying that is that there's a market, right? And if these giant, massively distributed contracts had a really unfair term in it, eventually people would notice and there would be market pressure to change it. It was always a little idealized, but you can kind of see the logic there, right? And there was this theory called the informed minority theory that said it didn't take that many people, only a few people, to notice these bad terms, and they could exert pressure on the market, and suddenly, or at least over time, I should say, eventually things would correct themselves. This made courts more comfortable with enforcing the contracts as they were written, even though they knew Molly or Tom didn't actually read the contract like the law suggested they did. But now, sellers, at least online or through apps, they can kind of figure out who the informed minority is ahead of time and pick them off. What if I'm an uninformed reader of a contract or a non-reader of a contract, like most people, and even I who teach contract law, I'm often that person, right? And I'm seeing one thing, and the person who actually would have exerted that market pressure is seeing another thing because the model has predicted correctly that there's someone who cares a lot. A different way of putting this is that complainers actually serve a very important market role. Complainers help alert broader masses of consumers to stuff that's going wrong. Who among us has not Googled, is this a scam, right? We read Yelp reviews, things like that. But again, what if the seller can figure out in advance who the most likely people are to complain, or who the most influential people are, right? Who has the broadest social networks, whose complaints would actually make a dent? And what if it could treat those people differently so that their complaints never arose in the first place? And also, is this a problem, right? Maybe it's a good thing. Maybe we're rewarding people who are paying more attention, we're incentivizing everybody to be a more informed consumer, but there are also lots of reasons we might not like this outcome, right? So this is just an example of how there's theory underlying contract law that needs to kind of be updated, or at least we need to think about whether it matches the current reality. All right, next issue, negligence, okay? So this is a tort issue. Negligence law, also the common law, which emerges out of England, so it's not like there's one big federal or even one big state statute passed by legislature that governs this stuff. The idea behind negligence law is, again, it's kind of the state regulating private duties to each other, right? I have the duty not to act negligently toward some people, right? Not all people, because I don't know everybody, but if I'm in a certain kind of relationship with somebody and I fall short of standards of reasonableness, which is what the law loves to talk about, then I can be held liable if I cause harm. That's like the basic structure of tort law, right? Okay, what do we do when all these sorts of human decisions that used to be human decisions are now AI decisions, or at least AI-assisted human decisions? So I'm drawing here from the work of a scholar named Andrew Selbst, S-E-L-B-S-T, if you're interested. But basically, one of his big points is we've been using technology for a long time, and actually, negligence law has been pretty good about figuring out what to do with that. You can use technology well, or you can use it poorly, right? You can uphold certain standards of how responsibly you're choosing and using your technology, or you can't. And in some sense, that's a very flexible concept that, like, maybe is fine for the AI era. But he thinks it might not be fine, and there's a few reasons it may not be fine. First is the kind of famous black box problem, right? A doctor may not know every detail of how an MRI machine works, but a doctor generally knows the sorts of things an MRI machine is going to pick up, the sorts of thing an MRI machine is not going to pick up, and kind of what to do with the picture that emerges at least a high level of generality. When we use, and this I'm using Selbst's example, when we use AI-assisted cars or AI driving, right, the AI is kind of replicating, as Selbst puts it, what humans do, but maybe better or more efficiently, right? And so where it goes off course, we can kind of compare it with how we would do the thing and say, okay, I'm gonna correct this, right? And the law, negligence law, can say, you did a bad job of that, right? You had a duty to know that even though the car was moving forward, there was a pedestrian there that it didn't notice. You saw that with your eyes, right? You could fix that. But sometimes AI is doing things that actually we can't do. They're just a totally different kind of decision-making process. Discovering correlations or mathematical relationships that are more complex, even than the word correlation suggests, that we can't really compare with any other way of thinking about it. And so there's this weird situation where, on the one hand, the AI might get it wrong, because AI does get it wrong, but the bar for a human to decide to override the AI from a liability perspective might be very high, right? There's strong pressure from the law, perhaps, to say, well, I don't know better than the machine, and if I think I do, I better have a good story as to why, and if I don't know how the machine works, I'm not gonna be able to tell that story. In conclusion, I agree with the machine. This is relevant to all sorts of things, but medical diagnosis is just one all throughout there. So we can have a longer conversation about negligence and tort law. If you're interested, feel free to ask in the Q&A portion. All right, couple more. I'm gonna be selfish and draw from my own research here. So, anti-discrimination law, right? You all have probably heard of something called protected classes, right? At various levels of law, constitutional law, federal statutory law, state law, sometimes city law, ordinances. There are groups of people where we say, because of historical disadvantages or injustices, here's a group that gets extra protection, which usually means that there are lots of things you can use to make a decision about another person in some context, like hiring, right? But these are things you can't use. You can't discriminate against people in these categories. Even that question is very complicated. What does it mean to make a decision on behalf, or on the basis of, right? Race, gender, disability, things like that. But the basic structure is there, and our law's been dealing with this for a while. One of the things I'm really interested in, though, is what if our list of groups at risk is now very incomplete? right? There's been a lot of writing about how AI kind of sucks up data from the world and can reproduce its biases. You've probably all read things about this, right? And so it poses a special risk of taking society's biases, racial, gender, disability biases, things like that, laundering them through an algorithm and kind of reproducing the biases in a more invisible form. That has been written about for years. We haven't solved it. Again, this is kind of an old problem, but it's there. But where a lot of my interest lies is saying, what if there are new groups that the law isn't describing, that we don't have names for, where we might be a member of the group and we don't even know that it is a group or it's being treated as a group, but actually our having that feature, being a member of that group, causes me to be harmed in some way. Maybe I'm charged higher prices on a travel website. Maybe my return isn't accepted at the store. These are pretty low stakes things, right? But they could be higher stakes things. Algorithms are used in sentencing sometimes, which I'm going to talk about for a second. So what do I mean by these new groups? So we're in 2024. 8 years ago, Cathy O'Neil, in a great book called Weapons of Math Destruction, which I highly recommend, talked about some of these groups. If I recall correctly, it was actually for-profit colleges and universities that created these kinds of data-driven profiles of a variety of people they were going to target for certain kinds of ads. And I'll just share a couple of the names that they gave to those groups. One was low self-esteem. People with low self-esteem are not a protected class. Yes, sometimes people with low self-esteem might have a protected disability, right, like depression or something like that. But we've never really thought about what the world would look like if sort of certain classes of businesses or the government could assess in advance who was feeling confident and who had low self-esteem, right? And if there are people with longer lasting self-esteem issues. Maybe we care, maybe we don't, but it's probably worth a conversation. Another one, and this is a direct quote, the category was called few people in their lives who care about them. Okay? And now, I'm just going to repeat this, let it sink in that that example is 8 years old, which in AI terms is like decades, right? So these are just a couple. I'll add a couple more. The FTC in the last couple of years filed a complaint against a data broker called Kachava, and the researcher in me was giddy because there was a whole new list of groups. Now some of the groups you might think wouldn't be protected, but maybe they would be. So as an example, people engaged in elder care were a group, right? Why might that already be protected? Well, maybe people who are targeted for higher prices or poor treatment or who don't get hired because the model says this person spends a lot of time on elder care, maybe they're being targeted because of association with a person with a disability, right? Which actually is in some senses covered under the ADA, but maybe not, so that's an open question. But others I actually am not sure are covered at all. So another category that this entity, Kachava, was kind of labeling people with was bereavement, right? People who've recently experienced a death in the family, or of a friend, or bereaving anybody, that's not a protected class. And you might think, and this would be very fair, okay, but most protected classes are things that are true about the people for a long time, right? Most people are members of one racial group most of their lives, right? Most people with disabilities most of their lives. But maybe not, actually, and disability is the key example here. In disability activism, people often talk about how most of us are going to be disabled at some point in our lives, right? And that's true, if you think about it. Even just being very, 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 very old usually comes with some degree of disability. And that's really interesting because it suggests that these questions of protected groups or protected characteristics, it's not a question of us versus them or these 5 groups and who's winning and who's losing. It's kind of a question that might affect all of us even if a group doesn't describe us right now. And so these are the sorts of conversations I think we ought to be having. Is this the kind of basis for a decision that I think is fair? It might not affect me now, but it might affect me later, or it might be the kind of thing that I just don't want being surveilled about me and used against me in decision making, right? So that's another example of our anti-discrimination law kind of assumes that we know who's at risk, and to the extent we study AI and anti-discrimination law, which is a very fertile and exciting area of research, it is usually focused on the groups we already know about. And again, I think that's actually an appropriate focus. That's probably where most of our attention should be, but it's an incomplete conversation. All right, One more thing, one more case study. And this is going to get a little technical, but I do not feel guilty for getting technical at a space conference. It's just a different kind of technical. Raise your hand if you've heard of standing as a legal issue. All right. Anyone want to hazard what it is? Or if there's a lawyer, but if there isn't, that's fine.
In layman's terms, you have a leg to stand on in the argument. You have something at stake in the
Yeah, I'm going to take the second part of what you said, but that's very right. Yeah. So the idea behind standing, which is means a lot of different things in law, but I'm going to focus on the constitutional issue of standing. It's an issue of federal constitutional law that affects all of us in every state. Is exactly what you said in the second part, that you have some stake in the matter. What does that mean? You can't just show up to court because you're like upset about a thing. You can't just show up to court and say, I'm suing because I don't like that the government did this thing and they didn't have the right to do this thing. What's interesting is it doesn't even matter if you're right. Like, you could be completely correct that the government, let's say an agency, made some decision and didn't follow normal processes. But usually, there are exceptions, usually you have to have some stake in the matter to show up and kind of take up the court's time with the issue, and to have this kind of awesome power of, hailing a government agency into court and forcing them to answer, right? And this makes sense if you think about it. But some of the ways we think about standing, which a different way of putting that is some of the ways we decide who gets a day in court and who doesn't get a day in court, who gets turned away from the courthouse door. Some of these questions make certain assumptions about the world that seem a little off. So what do I mean by this? To have standing constitutionally, this comes from the Supreme Court, you have to have something called an injury in fact. And that injury has to be, quote, concrete and particularized, and it has to be, quote, actual or imminent, not conjectural or hypothetical. So that's the Supreme Court's language. This has made it already very difficult to assess standing in cases where people articulate a risk of a future harm. Okay? This is actually an old problem. But you can see how this gets much more serious with AI. So if someone has taken our data, a particular kind of sensitive data without permission, and they've done it in violation even of a specific law that, say, Congress passed or the Alabama legislature passed, you still don't have the right to be, at least in federal court, so let's use a congressional enactment, you still don't have the right to be in federal court to sue them over it, or to try to get the data back or force them to delete it. It's not just about money. You don't have the right to bring them into court at all unless you can articulate what the Supreme Court calls a concrete and particularized injury in fact, okay? So how does this work? A couple interesting examples. There's a case called TransUnion v. Ramirez, and I'm gonna muddy up the facts a little bit because I don't have them in front of me, but this is the general idea. Some poor gentleman was trying to buy a car, and the salespeople told him, I'm sorry, we can't sell to you because TransUnion's people profile of you suggests that you are a potential terrorist, and that you're on some list that we can't, that we can't transact with. So his wife had to buy the car in her name. So he led a class action to basically say, not only was this wrong, but there are specific procedures that TransUnion and other credit reporters are supposed to follow to make sure that there's like a minimum degree of accuracy in what they're doing, and they didn't even come close, right? And I forget the specifics, but it was things like only using some of the social security number, but not all of it, things like that. And this went all the way to the Supreme Court, among other things, on standing, because they were like, okay, but what actually happened to you? You got the car. And what the Supreme Court said is, okay, actually he does have standing. He does have standing. But why does he have standing? He has standing because they told someone else, the company, the defendant, told someone else a bad thing about him. And that's an injury that we've recognized for a long time, right? And you can imagine how this might work, defamation law, right? Stuff like that. That's an old injury. You don't need AI to think about that. But it said all the people who are members of this class who were called a terrorist or potential terrorist internally in the system because of a violation of the law, like people where also they didn't follow the procedures, they were labeled potential terrorists, but who never actually reached the point that the lead gentleman did. They never actually got to a seller who said, sorry, they had no proof that the information was distributed. They didn't have standing because they said that is too hypothetical an injury. Now, this was a close case, but they said that's not standing, the risk is too abstract, right? I don't want to suggest that there shouldn't be a standing doctrine or that we don't have to have some limits for who can come into court and try to enforce the law, but you can see how the use of data, even data that doesn't seem sensitive at all, could be used in the future in ways that would bother us. And right now, I don't think the courts are particularly attuned to how those risks work or how to separate the serious ones from the unserious ones. So one quick example, TransUnion, the case I just talked about, is based on an earlier case, but from not that long ago, 8 years ago, called Spokio. And in Spokio, complicated case, but basically the Supreme Court said, okay, this guy has, once again, sued for a similar reason. Spokio, this People reporter, like a credit reporter, said things about him that weren't true. Like, if I recall, he was married, but he wasn't married. Had these features of him that were wrong. And they arrived at those, again, by not following the procedures the law says they have to follow. And the law specifically says that if this happens to you, you can sue. But standing comes from the Constitution. It kind of trumps a law. So the Supreme Court said, we still have to see if he's harmed enough to be here in court with us. And they said, we don't know. So they didn't say no, but they said, we don't know. We have to send this back down to the lower court to ask some questions about whether he was harmed. But in the course of providing some guidance about how to think about this, there's this quote, and I'm sorry to beat up on Justice Alito, but he wrote the opinion. And I'll just share this quote with you. And they were attempting to pick some things where you wouldn't need any further evidence, like saying you committed a crime when you didn't commit a crime, I think was their example of we don't need to know much more. Like if they told someone else you committed a crime and you didn't, the harm is obvious. But here's their example of the other end of the spectrum. In addition, not all inaccuracies cause harm or present any material risk of harm, any. An example that comes readily to mind is an incorrect zip code. It's difficult to imagine how the dissemination of an incorrect zip code without more could work any concrete harm. So that kind of shocked me when I read it, because redlining is a thing, but you don't even need to know about redlining to get there. There are all sorts of research teams that for years have shown that where you live, or not just where you live, but where you're using your computer or your phone, has all sorts of effects on what happens to you, right? Yeah, maybe it doesn't usually, but it's not hard to imagine. And I certainly wouldn't make zip code one end of a spectrum where like that's the obvious kind of innocuous, non-sensitive data point where the risk is so abstract, so hard to think about that we should kick you out of the courthouse door before you even get, for instance, discovery or anything like that. So just an example where, again, we've gone like a little bit, I think, astray, or a better way of putting it is we have failed to update these quite old legal categories to account for different kinds of risks and different kinds of harms. All right, almost done, I promise. I'm just gonna throw out, without talking about them in detail, a few more so you get a sense of the scope of this problem. If you're interested in one, ask about it. So, one, jurisdiction. Where does a thing happen? Literally, it's like a metaphysical question. It's very hard though. If Illinois says, I can't take your facial recognition data without your permission, but I take your facial recognition without your permission sitting on a computer in Idaho by scraping a picture you put on Facebook when you were on vacation in California, and the data center is in Texas, does Illinois have the right to regulate that? Even if Illinois says we only regulate injuries that happen within our borders, did the injury happen within your borders? I think there's a pretty good argument that yes, it did actually, but it's a very hard question, right? So one question is just, where does a thing happen? This has been hard forever. So even in the 18th century, there were hard cases about this involving steamboats and things like that, or 19th century, I should say. But it's basically getting harder. And when the internet showed up, it got even harder. But you'd be kind of surprised maybe to learn that we haven't really worked out the internet version of this problem either, like the old-fashioned version of like I bought a thing on a website, like which court controls. There are tests, but they're what we like to call very undetermined in law, meaning it's really hard to tell what the answer is ahead of time before a judge gets a hold of it. Another one is blockchain and crypto. The nature of the blockchain, right, and blockchain decisions is that they are made in a decentralized fashion, often using computers or nodes, depending on how you want to talk about it, in lots of different places at the same time. And that can even influence which country you're in. So like blockchain transactions on the Ethernet, for instance, they involve nodes all over the world, and courts have had to answer this question. Well, a majority of nodes aren't anywhere. They're in a lot of different countries. The US has the most, or it did as of the time this case showed up. Is that enough even for the US to have jurisdiction over this question? Is this a really domestic problem? Very hard. And then, like, a similar kind of difficult one is, and I'm borrowing here from the work of someone named Salome Viljoen, a lot of privacy law, the way privacy law is set up, is meant to say, all right, I control my data, right? I control my data almost like it's property. Maybe not the best framework to think about it, but it's mine, it's personal to me. I decide whether to tell someone that I'm pregnant. I decide whether to tell someone that I've committed a crime. I decide whether to tell someone how many bags of dog food I bought last month. I decide whether to share with someone my facial recognition data, et cetera. Pretty easy concept. Except now it becomes really hard. And Professor Viljoen has this genius article where she points out a kind of obvious fact, but that law hasn't spent a lot of time thinking about. And that's this. If you and I are sufficiently similar people, even kind of similar people, and you care a lot about your privacy, but I don't care at all, and I share a lot of data about myself, decision makers can now model your behavior based on my decisions, even if you haven't shared very much, because we're sufficiently similar or we share some key characteristics. But privacy law isn't set up to think about this at all. You have no right to tell me what to do with my data. The problem, though, may be in the words we're using. Maybe it's not just my data, right, if it can be used to make decisions about you. But how you'd even go about that, very, very hard, and I don't have an easy answer. All right, I'm gonna wrap up so we have time for questions, but I just want to kind of leave you with hopefully just a sense of urgency, but also a sense of possibility. These are some pretty technical questions I know that I shared, but even some very deep questions about what kinds of decisions we should be able to make about each other, what kinds of decisions the government should be able to make about us, who should know what about whom. These are deep questions that AI makes, I think, even more acute, but we're behind. We have decades worth of unsolved puzzles from the first generation of machine learning, and it's only gonna get tougher. And so I hope to leave you with a sense of urgency, a sense of possibility, and also the sense that there's something to be had in these cross-field conversations, in these connections between law and politics and policy and STEM, and also fields that aren't in either bucket. This affects all of us, whether you're in business, whether you're in education, it comes up everywhere. And some of these very challenging questions don't have a technical answer. They have to be answered via tough questions about, again, ethical, moral, democratic questions. So I'll leave it there, and I hope we get some conversation going. And again, feel free to ask me about anything I've said or anything I haven't said. But thank you very much.
Do you see this getting better with the presence of Web3 and different things like that, providing some anonymity for their users?
Providing, what's the last thing? Well, I couldn't hear your word.
Like anonymity, like the anonymous nature of using a Web3 browser.
Oh, that's a good question. I'll answer it a very at high level. I have detected almost no optimism, at least among the legal scholars who study anonymity, that we've reached tech solutions with broad enough adoption that you can't at least do a pretty good job of figuring out who's who given enough data. But I think that, I don't want to throw out company names or plug anyone, but there are tools out there that I think if they were really broadly used and became part of our way of doing business just as private people, would make some of the problematic things I'm talking about harder for bad actors to do or actors to do, because again, sometimes we don't know if they're bad or not. So yeah, I think there's some potential there, but I think getting it to a point of really widespread adoption is a challenge. Getting it to a point where the kind of popular use of these technologies is ahead of the curve, and the folks who have a really strong motive, be it on the government or business, to make these predictions about people and profile them, to make sure they're not a step ahead of the latest broadly used technology, huge challenge, and requires a robust and continuing public conversation. But yeah, I think there are seeds there. It's just, we're not there yet.
So you talked about how an algorithm incorrectly saying you've committed a crime, bad, What about with GPT and other chatbot hallucinations? How does that factor in? Can you get in trouble, especially if you maybe encourage the hallucination? Like, tell me about the crimes of such and such.
Totally, no, great question. Again, the macro theme is we haven't solved version 1, so we're really far behind on solving version 2, except in one sense. It's really good that this question keeps being asked from a legal perspective. Why do I say this? Because a lot of these legal standards are phrased in terms of what people know or what a reasonable person would know. And that could be a subjective standard, what you knew, or an objective standard, which isn't really that objective, but it means kind of what reasonable people in general know. A lot of tort law works this way, but there's other law too. We're all kind of learning that this is a thing, right? And maybe the first or second or 100th person to encounter it would have a pretty good argument for why they shouldn't be liable for some harm that results from it, but the millionth person won't have that kind of argument, right? And so from my point of view, the fact that this is a thing that people talk about is good at helping us solve these problems. The second thing is that a lot of times, not always, but a lot of times the hallucinations you're mentioning, and this is really important, are things that are falsifiable in the moment. The moment you get told about something, sometimes you have the ability to double check that. Sometimes you have the ability without looking anything else up, it's just obvious. But even if it's not, there's a way to double check, to cross-reference. You can even build other algorithms to cross-reference and double check, right? The more falsifiable in the moment the thing is, I think the easier it is to establish, just for example, like a liability regime around it. Where Professor Selps says it's really hard is things where the algorithm is wrong, but it's like a prediction where the wrongness won't exist at time 0, right? It's like emergent. It won't be clear that the algorithm got it wrong until much later. Or sometimes there's actually no way to do it, meaning maybe the algorithm counsels a certain treatment, medical treatment, but there's no way to know what the counterfactual would have been, right? And so in some ways, I actually think hallucinations might be easier than some of the questions I'm talking about. That does not mean we have solved it. I just mean, as I try to think through like where I would start, I actually have an easier time with hallucinations than I do with other things. One more thing on that. You may have read about lawyers citing cases that don't exist. That's one where I'm not sure we need new rules at all. Maybe we do. There are courts promulgating all sorts of rules about lawyers using AI, and that's probably a good thing, but we already have ethical duties that govern, for instance, whether or not we've taken the necessary time and used our expertise to ensure that our filings with the court are correct. It doesn't matter whether you used Google, LexisNexis, Westlaw, or ChatGPT, that duty is always with you. And you can't, I didn't read the case myself is never a good look before a judge, and I don't think AI really helps with that.
I wondered if I could ask a question about some of the challenges in terms of intellectual property rights. So, there have been some indications that, there may be issues of impinging or violating intellectual property rights. And I was just wondering, was there any case law made when Google, many years ago, maybe a decade or more, first was posting or making books freely available online? Because I think that question came up at that time. Was there any case law made then that would help with that question now?
So thank you so much for the question. You're going to be slightly disappointed in my answer, and I'll tell you why. When Nancy asked me to come, she said, should we ask any other lawyers to come, and if so, who? And I said yes, and that person should be an IP lawyer. And the reason I said that is not just because I'm not an IP lawyer, I'm really not an IP lawyer. IP law happens to be very, very specialized, and more so than most areas of law. And it is an area where, for instance, I don't know the case names off the top of my head. And so I don't want to tell you that a precedent exists or doesn't when I couldn't direct you where to look, except to say that in a general sense, you are right, that there have been cases about this, but in order to tease out, like I've been doing with the other areas, like why the new questions are so different from the old, I don't want to give you bad information. Two things in this, though. First, if you are interested in this, that IP lawyer is coming, and so he's talking tomorrow, right, Nancy? And I'm going to be there, and I want to hear what he says and ask him annoying questions. But the other thing is that people who are not lawyers underestimate how much time judges and other lawyers think about writing for people who aren't lawyers. What do I mean by that? Most legal cases should, in my view, produce an opinion that basically anyone who reads things in general should be able to read. And so as you know, there are new cases on this, right? Like the New York Times has its quite famous lawsuit against ChatGPT. This question, do the Google precedents cover us? The court's going to have to talk about that. And it will talk about that in terms that I think many people would be surprised, maybe they wouldn't, but some people might be surprised that actually they could kind of just get from the face of the opinion. So one of the ways I think actually to do some of the broader stuff I think we should do and encourage this conversation is lawyers need to take seriously what we sometimes say that we write for broader audiences and actually get these opinions into the hands of more people. But from your point of view, I would just encourage you to set Google alerts or however else you keep track of this stuff. Google Scholar, by the way, has 2 buttons you can push. One says articles and another says case law. A lot of people don't know this. So if you are interested in searching for cases on a topic in recent years, you do not need a subscription to the very expensive kind of really good archives we use, like Westlaw and LexisNexis. Google Scholar is great. There are a lot of other free ones. So this is just if you're interested, dive in. And a lot of the opinions are quite short. This isn't always obvious, so I'll just say it. The writing tends to be especially good and clear in appeals for a variety of reasons. And the trial level opinions just tend to be longer. They get more in the weeds for all sorts of reasons. So if you're interested in like, how far behind are we at figuring out this question? Does precedent cover us? Just highly encourage you to pick an appeals court or 2, use Google Scholar, and see what they're saying about it. I do that with all sorts of areas of law that I'm really not an expert in, just to kind of take the temperature of the courts. So sorry if that's really disappointing.
Hi, you talked earlier about if we could all just sit down and start talking about this. I probably speak for everybody in the room when I say that we all have fears about what's happening. What is it that we can do to create that conversation, and who does it have to happen between? That's my first question. The second question is, why is it so hard for us federally to not put basic guardrails in place, such as everything created that is AI needs to be labeled as such. Any AI-generated content needs to be cataloged for copyright or patent or intellectual property purposes. Whatever the law winds up being on that, at least we have this, right? Or we will not mass harvest information from public places. And just these basic guardrails might make some of us in this room feel calmer about the direction we're going in, but it seems like it's hard for us to get that going too. So number 1, what can we do about this? And number 2, why don't we have a basis of guardrails already set up in this country?
Great questions, hard questions, so I'll do my best. On the first point, obviously the conversation can't just be everyone everywhere all at once, right? So part of my academic work actually is trying to work out some answers to this puzzle, how to get from nothing to something. And so I'll just share my own view about how I think it could work, which isn't a direct answer to your question of what can I do, and then I'll try to answer to what can I do. My own view is that when we've faced problems before in society that are deep and structural, but also a little bit invisible and theoretically challenging, part of the way that we have tackled them is the people who are on the losing end of things, the harmed people, have gotten together and articulated arguments, legal arguments, but also moral arguments. Sometimes they're not arguments at all. Sometimes they're just telling stories, right? There's a really wonderful political theorist named Iris Young who's written about this. That's another one, by the way. You don't have to be a political theorist to read her. It's just, she writes wonderfully. And Iris Marion Young. And sort of drawing from her work and others, I think part of the answer is figuring out a way to make people who are on the losing end of some of these tools visible to each other and give them an opportunity to talk not just to each other but to other people. What do I mean by that? It could be everything from changing the way we do class actions and aggregate litigation to actually making transparency requirements for algorithmic decisions a little more collective or aggregate, meaning this isn't just how we made the decision about you, but here's where you sit. Here's how you compare to other people. There are actually some laws like that in certain areas of the economy, and so there's things we can draw from. But I think giving people a sense of where they're winning and where they're losing and why, that is kind of the fuel, I think, that's needed to get the conversation going. The entire legal system, at least in the courts, in this country is set up on the idea of the adversarial model, right? That the best way to arrive at truth and justice is to get people on two sides of an issue to make the strongest argument they can for their side, and then a neutral decision maker kind of uses that information to make the decision. There's something deeply, kind of small L liberal, like libertarian, almost very capitalist about it, right? It's like we're competing to get at the right answer because I have a stake in it. It's part of why there's standing doctrine, actually. I think we need to think that way a little bit. The questions can seem very abstract, but I think when we give people with a stake in the issue an opportunity to explain why what happened to them is wrong and unfair, that's actually one of the best ways for us to decide if we agree or not. And we won't always agree, right? In terms of what you can do, a couple things. One is, as I said, just honestly read more court opinions. Because a lot of the times what a court does is the following. They're not interpreting the Constitution. They're not interpreting 300-year-old contract law principles from England. A lot of times what the courts are doing is they're actually interpreting a law, like a law that the legislature of Alabama has passed or Congress or whatever. And if they get it wrong, at least in theory, the legislature has the ability to step in and change it, right? But this kind of dialogue that the courts assume exists, where like the democratic forces notice when a court gets a law wrong, doesn't happen much. There's a lot of scholarship on why. But in terms of what you can do, I think one of the best things to do is, especially at a state and local level, sort of try to keep track of how courts are interpreting laws that already exist on a thing, which are sometimes phrased very broadly using ambiguous language. And when, when an outcome disappoints you, angers people you know, that can be a flashpoint for activism or even for conversation. So I think that's like a really concrete thing you can do, and you can, again, set alerts for like Alabama privacy law if you live here or wherever. This connects to your second question, why is this also terrible? And I hope it's not too pessimistic, my talk. I mean, I'm not the person to, of course, to solve congressional dysfunction. That's a deep question for all of us. But I do think, again, states and localities actually are often a little less broken. And, we're a really big country full of people with really different ideas about what America means and how politics are supposed to work. It's part of why I get really excited to travel for talks, because I'm originally from Chicago. I live in New York. Huntsville has a lot in common with those places and is not like those places in other ways. And, it helps me understand what it means to be an American, to be here, at the risk of sounding too lyrical, right? But that's part of, I think, why the national conversation is so hard. We're a really big country, right? Getting anything done at the federal level is really hard. So again, starting state and local, and there are reasons for optimism. Illinois, my home state, made it illegal, or I should say unlawful, it's not criminal, but Illinois prohibited sharing biometric information without consent all the way back in the ancient days of 2008. Really ahead of its time. It took years for anyone to sue over it, and only in suing over it can litigants then force courts to actually interpret the words, figure out what they mean, what does facial recognition data mean, what is a voice print, we're still not sure. But this is kind of how it works. And Illinois did it. Why did Illinois do it? I wasn't a lawyer then, and I wasn't paying attention, so I'm just going to share the maybe apocryphal story for how it happened. But as I recall, some guy was working at a company where he used his fingerprint to clock in, which is not that unusual, right? The company then went bankrupt and sold the fingerprint data as an asset in the bankruptcy, okay? Apparently, it was the outcry over that led, this like one incident that led to the Biometric Information Privacy Act, which is broadly considered the strongest protection in the country. Some people think it's the strongest protection in the world for biometric privacy violations. Now, it's just a state, and as we just talked about, figuring out what a single state can and can't do is not easy, but you gotta start somewhere. And a lot of the other states that have passed biometric privacy protections in the years since have been inspired by Illinois. That doesn't mean they've all done the same things. Some have been inspired in a negative direction and have written quite different laws, but it's the famous, states as laboratories of democracy. I'm not sure that works so well on issues where we all pretty much know what we think already, but on new and unsettled questions, I actually do think the states can be those laboratories, even in states where you might otherwise be pessimistic about all sorts of things you care about. So that's what I'd say. I think federal level, it's gonna take a while, but even the feds will eventually, I think, draw their inspiration from how things have gone at a state and at local level.
I guess I had a hypothetical. End-to-end encryption, and I guess your thought that you're being private, and yet your digital dust or UTS or whatever is being sold for marketing, for whatever. How legal is that? I mean, it seems legal, but seems also an encryption in privacy.
It's a great question, and we love hypotheticals. That's how law professors do our job. So I'll just give an example because I can't say what every law would say about it, right? Most states have something called an unfair and deceptive acts and practices law, with the very exciting acronym UDAP. UDAP laws are generally phrased very broadly. They're kind of what I just said, like businesses don't have the right to use unfair and deceptive acts and practices. And over the years, courts have decided kind of what those words mean, what a plaintiff has to show, what kinds of business activities actually are fair as opposed to unfair. But there's still a lot of breathing room. And part of the idea behind a broadly worded law like that is actually that it can kind of keep up with the times, right? And so I think that lawyers have not used UDAP laws enough to attack the sorts of things you're talking about. But it depends on the representations that are made by the makers and sellers of those tools to the people, right? So first you have your relationship with, say, it could be a VPN company, it could be with your OS itself, it could be with the browser, right? So first you have your relationship with the thing, with the entity that said, we're keeping your data private, but they weren't. Maybe they knew they weren't, so that reaches a level of like willfulness, right? Or maybe they thought they were, but they did a negligent job of doing it. Maybe it's somewhere in between, right? So that's one question. I think UDAP laws actually, in some states, in some circumstances, can get at that. What makes it tough is there isn't like a law book you can look up where it says on page 147 that this is illegal. Figuring out the answer to that question requires lawsuits, usually. Not always, but usually requires a lawsuit. Someone has to get into court and ask the judge the question. And for someone to get into court and ask the judge the question, you need someone who thinks this is worth their time, which probably means someone knowing they were harmed by it, right? It also means knowing a thing at all, and a lot of what you're describing remains invisible to most of the affected people. But if you could get the question before the right judge in the right state, maybe is the answer. That's not the only way. Breach of contract in some cases could be used. Part of why my clinic is called the Clinic in Private Law is private law governs, is kind of our catchphrase for all these things where it's about our private relationships, contract, tort. It's not criminal law like what the state says I can't do. Private law offers some of these tools. But I mentioned this relationship between us and the thing, right? What's tough is sometimes the company that buys up our digital dust and uses it against us is a company we don't have any relationship with at all. We don't know they exist, right? And you might think, well, that makes it worse, right? It's even more invisible, even more anonymous, even more removed from any consent I might have granted. And as a moral or ethical matter, I would agree with that. It actually makes it legally a little tougher to go after them because they never made any representations to you, right, that you can say were false. That is not to say there aren't ways to go after them, and some of my colleagues are working on like very interesting answers to like what are the legal theories we could use. And among law professors, we often say, is this a thing that needs a new law, or is this a thing where actually we could use the law we have, the legal principles we have, to go after these questions? This is like a live question in the courts. Yet another one where if you have technical expertise, reading some of these decisions, these legal decisions about what is and is not a privacy violation might annoy you, and that annoyance is often the beginning of great things.
So on the other hand, law enforcement trying to get at end-to-end encryption has been super difficult. And how can we get these providers to encrypt so that we can enforce whatever legal to the threat that's causing the problem? If you, I know.
No, I think I understand.
Okay.
I'll just say that is also a live question. Like how much can companies hide behind? So this is like the opposite of what I was talking about, right? This is a company that actually either does or says it does care or says it cares about privacy, right? And is using those same agreements with their users to say, hey, we promised Tommy that, no one was going to see this. Well, first of all, I'll say I don't know what I think the right answer is, and I think it's probably very dependent on like the specific facts. But in a general sense, I wouldn't say that the courts have arrived at like a solid answer to the question. But this is, I think, a great one for public conversation. Like, everyone kind of gets the stakes. It's really easy to explain. And also, it's part of a broader conversation about law enforcement, right? It's part of a broader conversation about privacy. It really kind of highlights these trade-offs between privacy and security, or maybe they're, as Apple and other companies like to say, maybe they aren't always trade-offs. Like, maybe sometimes privacy and security go together. Which state actors? How do we monitor that they're doing it right? Do we just take it on faith that they're using it for the right purposes? Do they have to convince a neutral third party, like a judge or a magistrate, of it? We have some systems like that, right? We have the federal, the FISA court that has to approve certain kinds of intelligence requests. I am not going to come up here and say I think the FISA court works well. I don't. But we at least have, we have like wrestled with this concept before about a law enforcement or intelligence entity that says it needs a thing that would otherwise be protected with privacy. And I think that we can learn from how our original efforts at this, especially in like the FISA context, have worked well, or I actually think they've often not worked well. Sometimes because we can't read the opinions.
To what extent does model explainability impact liability determination? And are you seeing that businesses are using that concern for model selection?
Great question. I mean, this will be my shortest answer of the day. A lot to your to your first question. A lot, but again, how is still being worked out. So I'll just like a couple quick hypos. You can imagine a world where a more explainable model makes you more liable, right? As a business. Because someone harmed could come to you and say, it was clear, maybe not on the face of the thing, but you had the tools to figure out that this kind of thing would happen. You didn't use them. And so one thing I worry a lot about is actually that it puts a thumb on the scale in favor of less explainable models, that businesses actually have an incentive to hide behind the black box of an algorithm. And I wouldn't say I've heard a business getting up on stage and like bragging that they're doing this, but if I can use the very scientific term vibes, my sense is that this is a thing. I don't have empirical data to support it, but it could work in the opposite direction, right? You could certainly also imagine a rule where you say, actually, if you adopt an algorithm that you know isn't explainable enough to override intelligently, let's say, or to explain to a person the basis for the decision, then you kind of bear the risk of the injury, right? We often talk about presumptions in law, where if you can't prove a thing, someone has to kind of bear the risk of that inability to prove a thing. It's like a default rule. You could imagine a situation where you say, and I think actually Professor Selps might say this in his article, but I don't remember. Actually, that's on you. And so if we detected that there was a thumb on the scale in favor of black box algorithms and poor explainability, you could adopt this default rule to kind of try to balance things, to say, we're not going to prohibit you using an algorithm you can't explain. We're not going to necessarily make it illegal, although maybe we should in some circumstances, like sentencing. But like, we're not going to make it illegal, but we are going to say that if something goes wrong, that's kind of on you. You don't get to hide behind the lack of explainability. And that would, again, balance things and make decision makers say, all right, actually, to protect myself, I need to be able to have a bare minimum of information, or be able to provide a bare minimum of information, say, to the subject of the decision, so that they, in turn, can, for instance, consent in a way that would, get around liability issues. So it could actually work in a few different ways, and I wouldn't say that either the law or like business leaders have settled on an answer. This is just me sharing one way it could work.
Thank you so much.
Thank you all. Great question, seriously.